Good morning, everyone. We're going to give everyone a few minutes to jump in and get settled, and we'll get started real soon. Okay, well, we've leveled out with people entering the room. So, welcome, everyone. My name is Tawny Alvarez. I'm a partner in Verrill's Labor and Employment Practice Group. Welcome to Maine's 2024 Wage and Hour Report, Essential Insights for Employers. Um, Today, I am joined by my colleague Liz Johnston, who is an associate in the Labor and Employment Practice Group. And today, we're excited to provide a comprehensive analysis of the Department of Labor Bureau of Labor Standards Wage and Hour Division's recently published annual report on wage and hour complaints and violations in 2024. My apologies. Not the ideal way to start things off. I apologize. During the sessions, we're going to focus in on the most prevalent 2024 violations and offer an examination of the laws in which most penalties and violations were found related to, and then talk about ways in which employers can guard against, guard against future violations. For those of you who are not familiar with our webinar series, I'm going to ask Liz to take over introductions. I apologize, everyone.
Sure. The session will be recorded today, and we will plan to send out slides after the presentation is completed. If you do have questions during the presentation, we're more than happy to address those. So please feel free to drop those in the chat or the Q&A feature, and we'll try to get to things as we go. And depending on sort of timing and the nature of the question, we might save those till the end. But we do invite you to ask questions if you have any regarding the content today. Um, with that, I think we'll get started. I think that wraps up our housekeeping items. So I'll turn it over to Tawny for sort of our general overview of the session.
My apologies, everyone. So, one of the things that's important from a background perspective is to understand that in 2024, the Department of Labor regulations did change. So, they were changed to allow the Department of Labor the ability to collect not only unpaid wages, but also liquidated damages, interest, in addition to the penalties that they previously had been permitted to collect. This is important to understand because it's part of the analysis we're going to provide during the course of the presentation to get a full understanding of the effects of some of these violations. Understanding the background is really important. So in 2024, 581 cases were reported to the Department of Labor. That's not the number of calls that they received, which was over 15,000. Those are really true cases that were reported. Of those 581 cases, 277 were assigned for formal investigation. And of those 277, 101 of those cases resulted in a finding of a violation. And of those 101 cases, there were 7,817 individual violations. The entities that saw the highest rate of violations were food services, healthcare, and retail. Not only were those the ones that saw the highest rate of violations, they were the industries that saw the highest rate of complaints. So employees in those industries had the higher rate of complaints more generally. Additionally, however, the report itself doesn't identify the portion of our market that is made up of food service, healthcare, and retail employees. So it could just be that they represent a much larger proportion of our economy than some other sub-entities. Of those findings, the 101 confirmed violations, there were $1.7 million in unpaid wages that were owed to 820 workers. In addition, based off of those 7,817 violations. There was $1.9 million in fines, and that was based off of 88 cases of violations. So it's important to understand kind of this much more holistic data that we're going to then break down. The purpose of this presentation is not to shame or draw attention to past mistakes that employers have made, but really an educational opportunity for clients and friends of the firm to understand places in which people often make mistakes and then experience penalties and violations for violation of penalties for violation of the law. Um, Data concerning individual companies who were cited is publicly available on the DOL website. We will not be referencing any individuals during the course of this presentation. While the data that we're going to present today concerning 2024 is highly concerning, a couple of things to keep in mind as we move to 2025 and 2026 and the future more generally. The first is that the Department of Labor has changed kind of their processes. So they're not only responding to complaints, they're also taking affirmative actions to go out and visit and audit employer practices. So while previously most violations were discovered as a result of complaints, now could be discovered without a complaint and instead just sua sponte on behalf of the Department of Labor coming out and doing an audit. The second thing to understand is that the Department of Labor Wage and Hour Division under the Bureau of Labor Standards has partnered with Brandeis University, and they're in the process of developing some type of predictive modeling software that would help to identify high-risk employers and industries. This is really concerning unless we have further information about what subsets are being placed into those data sets. But for those of you operating in hospitality, we know that from a federal level, there's higher percentages of violations for labor and employment-based cases. So I think we will see an increase or a rise in audits and investigations into hospitality-based businesses. So that's just a very overarching background about all the things we're going to discuss. And now I'm going to turn it over to Liz to give a more detailed outline of different areas of concern that we're going to focus in on a more micro level.
Sure. Thank you, Tawny. So the wage and hour report for 2024 has an extensive list of violations of the various wage and hour laws, and there certainly are a great number of them in Maine. But today we're going to focus on some key areas based on areas where we see significant penalties and fines assessed against employers, as well as areas where we see common violations of these, and these are issues that many employers are likely to run into either on a day-to-day, or even sort of month-to-month basis. So we'll be covering child labor, record keeping, misclassification issues. One thing to be aware of is that misclassification, we hear that both referring to exempt, non-exempt employees as well as contractors, payment of wages, tips, tip pooling, tip retention, minimum wage, personnel files, and letters regarding termination, as well as other sort of laws related to the payment of wages to employees, earned paid leave, and sexual harassment requirements for employers in terms of training and posting of policies and legal principles. And with that, we will jump into child labor on the next slide. So this is a really significant area for employers to really have at the forefront of your mind if you are an employer that has sort of a policy or practice or permits the hiring of folks under the age of 18. We have the number of violations, cases with citations, and it's, a fairly low number compared to other types of violations, but this is an area where the fines are very heavy and the DOL is very interested in enforcement. And in fact, the 2024 report explicitly states, quote, While violations appear relatively few, they are the most serious in nature and require immediate resolution. Keeping our youth safe on the job is our highest priority, and these complaints are always the top priority for investigations. So this is an area where the DOL is looking, and they are not shy about implementing penalties, which can be very significant, and we'll touch on in a little bit. So in terms of the child labor laws, I want to just go through briefly some of the higher level principles related to child labor that you should be aware of. So there's a number of statutes that were cited in relation to the violations in the report and that cover child labor. And one of those is Section 771. This relates to the minimum working age being age 14. And under Maine law, the general rule is that minors under 14 simply can't be employed. But there are certain exceptions for agricultural work, as long as it doesn't involve hazardous machinery, a few other very specific carve-outs related to school lunch programs or businesses owned by the child's parents. But the general takeaway for Section 771 is that if you're considering hiring somebody under age 14, that raises a red flag, and you should be sure to check the applicable standards and be very precise about what that job is going to be. Section 72 is where we see more common violations because this is related to youth involvement in hazardous jobs. So when it comes to employing anybody under the age of 18, Maine law really draws a hard line around safety. And the takeaway is that anybody under 18 can't be employed in any job that's considered hazardous, dangerous, or likely to harm their health or moral well-being. And that also aligns with the federal standards that we see in place for child labor as well. So in terms of what's off limits, anything involving hazardous machinery, confined spaces, heights where there would be OSHA regulations that require extra precautions, those are going to be off limits. And hazardous machinery is broad. And the Maine DOL website has, and the rules related to hazardous jobs for minors has a really specific list of the types of work and machinery that youth can't be involved in. But we're not just talking about like bulldozers here. We're also talking about things like deli meat slicers and, more common machinery that you might see in the average workplace. So we need to be really cautious about minors engaging with that equipment. Jobs in the cannabis business are off limits, anywhere that sells cannabis products. And then sort of adult and entertainment establishments, obviously off limits, but that's expressly stated in the law. There are, again, certain limited exceptions to the hazardous work requirements. But if you're hiring somebody under 18 and there's the potential for the heavy machinery or hazardous equipment to be used, you have to check the regulations. Section 773A isn't included here, but it's another statute related to restrictions by age group, and it is sort of the general categories of work in which minors can be employed. It differs based on the minor's age. So minors under the age of 16 face the most limitations on the types of work environments that they can be involved in. They can't generally work in manufacturing, mechanical businesses, hotels or rooming houses, laundromats, bakeries, certain commercial amusement venues. There are certain carve-outs, for work in places that produce ice cream or certain areas of a hotel. But again, without going into too much detail for today, with our time constraints, just being very cautious and checking those regulations if you are employing a minor is really key. A place of heavy penalties and fines, especially for this past year, is Section 774, because this relates to the hours that kids can work. Because even when a job itself is legal for a minor to engage in, the hours per week and the hours per day are tightly regulated for minors. So for 16 and 17-year-olds who are in school, no more than 24 hours a week while school's in session. If school's not in session, that jumps up to 50 hours a week. There's also daily limits. So minors who are 16 and 17, 6 hours maximum on school days, 8 hours on the last day of the week, 10 hours on non-school days. Can't work more than 6 days in a row. Again, am sort of rattling off all of these just both as an informative piece, but also just to emphasize again how regulated this area is. There's work hour limitations, minors can't work between 10:15 on school days, midnight on non-school days, can't start before 7 a.m. on school days, and so on. The limits get even stricter for minors who are under the age of 16. The hours per week drop, 18 hours a week during school, 40 when school is out. There's more restrictive hours per day when those kids are in school versus out of school. And similar to the older group of teenagers, can't work before 7 a.m., not more than 6 days in a row. So all of that to say, this is an area where we do see a lot of violations, especially Tawny mentioned that the hospitality industry is, found to be a common area of violation for the DOL. It makes sense. I mean, restaurant hours go longer than the state permits minors to work. But it's important to be really cautious when scheduling and making sure that you are abiding by those hour limitations to avoid penalties.
And just to add to that, the AM PM work hour limits is really important because if you schedule someone to work till 9, but there is some type of cleanup that's required afterwards, any minute past 9 is a violation, right? So you need to recognize that, yeah, it's not resulting in overtime, but there are those time limits. And if somebody has to clean up or close something down afterwards, that's time worked and that's going to result in a violation.
Absolutely. That's a great point. The last section we wanted to talk about here is section 775, and this relates to work permits. This, again, a source of heavy fines and violations. And what you need to know is that before you hire anybody under the age of 16, they need a work permit. And that needs to be a permit signed by the school superintendent, issued by the Maine Department of Labor. And one thing that sometimes gets missed is that each work permit is specific to the job and the employer. It only applies to the exact job stated on the permit. It's not transferable between employers or among different jobs. So if you are employing somebody under the age of 16, you have to go through the permit process. And there are also limits for minors on how many permits they can have. During the school year, they can only have one active work permit. During the summer, that goes up to only two. In terms of penalties, I've mentioned these are heavy. For first violations of child labor laws, penalties are no less than $250 and no more than $5,000. But those limits go up for second violations and for third violations. For a third violation, the minimum penalty is $2,000 and the maximum is $10,000. And there's also the potential to really escalate penalties based on multipliers for violations as well as intentional or willful violations of the statute. And, one of the cases that we saw from 2024 is, the DOL looked at an employer's history of issuing or obtaining work permits for employees, and then one year they didn't. And so they interpreted that as you knew what your responsibilities were, and so this was a more severe violation, even if it was an oversight or whatever the explanation was. But these are really serious consequences. So be careful and check the statute and the rules. With that, we'll go to the next slide and I'll turn it over to Tawny.
Great. So we're going to talk about record keeping, everyone's favorite topic, I know. So we put down kind of the key elements of each of the laws that are relevant to this, which is section 622 and section 665. So under section 662, employers are required to keep records showing the date and amount paid to all employees. So that's keeping track of kind of the pay stub record more generally. And then they're also required to keep track of daily time worked by hourly employees. That provision of 622 is the one in which we see the most violations regarding, because we have employers who ask hourly employees, hey, just certify the number of hours you worked this work week. That's insufficient for our hourly employees. We need the number of hours each day that were worked. What I see a lot of times is an employer who has the record showing the amount paid, showing that 40 hours were paid, but no similar record concerning the number of hours worked. In some cases, this is because there's no process in place with the employer. They get an email or there's a verbal exchange or a text message, and that data is never later maintained in some format. And I see this a lot in hospitality, kind of more generally, if they don't have a very specific time card punch in, punch out system. So, as it relates to best practices to keep yourself out of non-compliance under section 660, 622, have a process in place where an individual is clocking in and clocking out, and that your payroll records are paying based off of kind of those times specifically. If you don't have a clock in, clock out process, have another way in which employees are able to record hours worked in real time, right? As opposed to waiting till the end of the week and providing that data in some format. It doesn't have to be a time clock. It could be a sheet of paper that you are scanning daily or hourly to maintain those records. But the biggest violation we see usually is under 622 as to failure to record the hours worked on a daily basis. Similarly, we see a host of different violations under 665, and that requires employers to maintain records for hours worked and wages paid for a 3-year period, with also providing, has two elements, employees every pay period with a pay stub that shows the hours worked during that pay period, total earnings, and itemized deductions. Where we see the most number of violations for 665 in our experience has been a change in a payroll processor. It sounds really silly, but we are seeing more and more clients who are changing payroll processors on a more frequent basis. And when they change their payroll processor, they are finding out that they don't have access to their previous provider's data or information. Or once the contract is terminated, they haven't downloaded that data into their own system. And by the time an investigation is occurring, they've lost access to that data or information. That then results in a violation for each employee for each pay period in which it's at issue. So while the record keeping dialogue is usually like a snooze fest, absolute snooze fest, right? Look at the sheer quantity of fines assessed as it relates to Section 622. So almost $250,000, $216,472. There were 72 cases in which this was alleged as an issue, and 21 cases were found to have issues with 10,940 violations determined. Why is that number so high? Because remember, you need daily records of time worked by employees. So if someone works 7 days, but you don't have daily time records, that's 7 violations right there. So understanding that data is really important and making sure that we're keeping up to date on the paperwork aspect of the operations and employee work hours. As it relates to Section 665, in a lot of situations, we'll see a wage statement that might be missing the itemized deductions or something like that. We saw 7 cases that had citations with 59 cases alleged. 3,907 violations were determined with a much lower fine assessment rate, with only $6,000 in fines assessed under that one. We do have a question. Is the daily record keeping for hourly employees only, or salaried employees required to fill out time cards? It's only related to hourly employees. However, right, be mindful of situations in which the Department of Labor finds that an individual who is salaried was improperly classified as salary and should have been hourly. Liz had a really big case last year in which this was the case, in which a salaried employee was determined by by Department of Labor to have incorrectly been classified as salary exempt and should have been an hourly non-exempt employee. And then we didn't have any records at all about time worked more generally, which creates a host of different issues, both as it relates to a potential litigation with those claimants as well as an investigation by the Department of Labor. So a really good question. We have another question, which is, does the 3-year requirement for hours record retention align with the statute of limitations for wage and hour violations? Another really good question. No. The statute of limitations for wage and hour violations is 6 years. You should be keeping your records for up to 6 years. Now, the Department of Labor is only going to do the investigation for the prior 3 years, but in most cases, our experience has been they're looking 2 years backwards. That's the data that they're going to ask you for. And if they find significant violations, they'll ask for that 3rd year, because under the statute, the 3 years, there's differences in 2 years, 3 years, and the 6 year. But everyone should be keeping these records for 6 years, because under Maine law, if you're sued by the employee, the look back period is going to be 6 years. So really good question. And with that, we're going to talk more about paperwork, but not from a record keeping standpoint. And Liz is going to talk about employee misclassification.
Perfect. Thanks, Tawny. And I'll just add on to what you were talking about in terms of the record keeping and the issue with salary and salaried employees and having time cards. It's not just a penalty issue or a fine issue for those particular matters. It becomes an issue of back wages as well. So if there's an employee who is working more than 40 hours a week and will say that they were working more than 40 hours a week, that potentially puts them at for having exposure for overtime, and then not having records to refute that becomes difficult, and there's potential for treble damages for the back wages owed through that very long statute of limitations period. So misclassification, this is another area where we wanted to highlight from the DOL's report, specifically when it relates to misclassification of employees versus independent contractors. So an employer that intentionally or knowingly misclassifies an employee as an independent contractor, it's a civil violation, and it can result in fines of $2,000 to $10,000 per violation. And it's important to note that per violation means per person, per individual. So an employer with a team of 10 contractors who are misclassified, multiply those fines by potentially 10, because it would be 1 violation per instance in person. In addition to just the penalties, misclassification has other liabilities as well. There's potential overtime liability for similar reasons we were just talking about. If somebody's not classified as an employee, but they were working more than 40 hours a week, we have potential overtime liability and unpaid wages. There's also potential consequences related to unemployment insurance, workers' compensation penalties, tax penalties and obligations due to failure to withhold relevant payroll taxes. So all of this together makes misclassification a potentially expensive deal. So it's important to get right. Generally speaking, if you're not sure how to classify somebody based on their duties, and we'll talk a little bit more about that test in just a moment, it's a great idea to consult a legal professional on that. But at the very least, take a look at the independent contractor tests, both for the state of Maine and federally, because these can be a good place to start in determining if somebody is properly classified. So in Maine, there's a 7-step sort of checklist or test to determine whether an employee is properly classified as an independent contractor. And it is not the easiest test to meet. The first step is that the individual has to be free from direction and control of the employer. So you need to ask yourself, are we directing how this person is doing their work, how they're getting to the final, end result of the project? If the employer is dictating that, you need to stop there. That person's an employee. Another factor is, does the contractor or the individual control the means and the progress of their work? again, how the work is done, not just the final outcome. If the employer is involved in those details, those processes, and setting the path to that result, that person's likely an employee. Other relevant factors, if the person's engaged in an independent business or trade for the particular work that they are doing for the employer, that's helpful on the contractor side. But if they're not, they're looking more like an employee. And the person also needs to be able to profit or suffer a loss based on their performance. So if they're guaranteed payment no matter what, given being paid on an hourly basis, for example, then they're probably less likely to look like a contractor. There needs to be some sort of financial risk, some sort of incentive to use their time efficiently, use their materials efficiently, earn more money or lose money as a result of the way that they're doing their work. Number of other factors as well in terms of, does the contractor have the ability to handle their own staffing to assist with the work? Do they hold themselves out as available to do work in their niche for other employers as well, other entities? Whether they've invested in their own tools and equipment for the job, whether there's a written contract. One misconception that we see, pretty frequently is the thought that a written contract stating somebody is an independent contractor means they're an independent contractor, but that's not always the case. Even if there is a written agreement, even if the person has their own LLC, even if everybody agrees and wants to have this classification as a contractor, that won't necessarily mean for the Department of Labor purposes that that person's properly classified. So it's really important to go through that factual assessment for each person to make sure that they're properly classified, both to avoid the significant potential DOL penalties as well as those other liabilities related to taxes and insurance and overtime that we talked about. Next slide, please.
So we're going to jump into full and timely payment of wages. So it's important to understand that employees must be paid at regular intervals that cannot exceed 16 days in between those payments. So all of this is found under Section 621A. Where we most often see issues with that 16-day period is employers who have monthly payroll processing. It doesn't happen often, but we do see that at some periods of time, or situations where the wages earned the pay for the wages isn't within 8 days of the payment date. So you couldn't have someone who, works one whole month and you're like, oh, the next time that you get paid isn't going to be until next month if you start work on the first date of the month before. So making sure that 8-day payment cycle is also met. It has to occur at regular intervals that the employee is aware of. So oftentimes when we look at handbooks, we'll point out to employers that they haven't identified what their work week is classified as or when pay is going to occur. It's important that we inform employees of the payroll cycle and that if it is changed at any time, that we provide at least 30 days written notice. So we can't just change it without providing written notice to employees at least 30 days beforehand. Additionally, we cannot charge a fee for direct deposit. You additionally should not be providing a fee for doing regular checks for employees. So no fee should be attached to or related to the payment process. And you must give prior notice to employees if the rate of pay is decreased. This is one area of the statute that I think is always surprising to people. Unfortunately, it doesn't require that you give 30 days notice of a pay decrease. It just needs to be prior to the application of that decrease in pay. If you are considering decreasing an individual's pay, however, that is a good time to talk to either in-house counsel or outside counsel about some of the risks associated with that, because it would be viewed as a form of an adverse employment action and how that could interrelate with claims of retaliation, harassment, or other similar claims. This was under 621A, 215 cases were brought to the Department of Labor's attention, and only 47 cases were found to have citations. In a lot of situations, the ones we see, at least as a firm, are the 16-day period, or failure to inform people of a change in the payroll processing date. 3,855 violations were found. Again, remember this would be based off of every single individual as a different violation, with fines assessed at $154,134. So this is a costly issue for the 47 cases that were found to have citations, or the 47 employers who were in violation of this provision. And with that, we're going to turn over to Liz to talk about some tip issues.
Sure. Thanks, Tawny. So on our tip slide, you'll see the fines assessed at a significantly lower number than the prior one. So it begs the question, why are we talking about this, right? There is a huge potential for violations here, both in penalties as well as back wages. So despite there were a high number of violations alleged, and despite the low number of fines actually assessed, we thought it was an important issue to touch on, both for purposes of the Maine DOL, but also because this is an area where the federal DOL enforces these provisions as well, not specifically as to Maine law, but to analogous federal laws. And the principles are similar in terms of both state and federal law. So it's an important spot to be aware of if you are an entity that is sort of more of a classic tipping situation, like a restaurant, as well as, having tip jars on the counter. These are important principles to know about. So both in Maine and under federal law, employers can use a tip credit. The tip credit can be up to 50% of an employee's hourly wage that's required. That would apply both to the state minimum wage in Maine as well as local minimum wages like Portland. So in Portland, the employee's wage is going to be just a little bit higher due to the elevated minimum wage, and the tip credit can only be up to half of that. Couple quick points about a tip credit. Employees always need to be informed in advance if the employer is going to be taking a tip credit. So they need to understand the wages that they'll be paid, the amount of, the tips that'll be credited toward hitting that minimum hourly amount with the tip credit. And generally speaking, employers can't keep any of an employee's tips. So another point we'll come back to that in just a minute in the context of tip pooling, but what's really important to keep in mind about a tip credit is that if an employer takes that credit, the employee needs to earn enough tips to bring them up to minimum wage. So they need to earn enough tips that, if we look at this on an hourly or weekly basis, they have made at least the hourly minimum wage rate that applies to them over the course of the week. Otherwise, the employer needs to backfill that with additional wages so that they are earning at least minimum wage. So it's not enough to just take the tip credit and call it good. You need to be monitoring to make sure that the employee is actually earning what they need to under Maine's minimum wage laws. So tips and ownership is one of the issues that is really important to understand as well. As I mentioned before, tips belong to the employee. So the employer can't keep any portion of an employee's tips. They can't require the employee to hand over half of them to, the general, to a manager, to the owners. Employers, managers, supervisors, owners can't keep any part of an employee's tips. There's only certain circumstance where an owner or a manager or a supervisor should be keeping tips as if they are solely providing service to the customer that is providing it. So a scenario where we see this come up at times is when employers use tip pools. So either a situation where employees are all contributing to one, tip pool for the night, or there's a, tip jar on the counter and customers put it in and employees share that. Even if a manager or a supervisor is providing service to customers and contributing to that pool and sort of acting in a tipped capacity with other employees, they should not be taking a portion of the tip pool because they are considered the employer in their role as a manager or a supervisor. Um, so when we talk about what a manager or supervisor is, this can be, somebody who owns the establishment. It could be somebody who's the, sort of front of house manager permanently. It could be somebody who's acting in a supervisory role for the shift. It's not clearly defined under Maine law what a manager or a supervisor is. And this is one area where Maine law differs a little bit from federal law because federal law has the same restriction on managers or supervisors or employers keeping tips in that they can't do it. But federal law provides a clearer definition about what that means. A manager or a supervisor under federal law is somebody who meets the executive exemption criteria in terms of duties without the salary requirement. But it's a little bit more vague in Maine, so it's just important to keep in mind that if those types of employees are participating in customer service and participating in a tip pool or receiving tips as a part of a pooling arrangement, that should raise a little bit of a flag and think about whether they're entitled to and permitted to be able to share in that pool under state and federal law. And with that, I'll turn it over to Tawny for the next slide.
Great. So Liz touched on it a little bit, but now let's talk about minimum wage and overtime. So in 2024, the hourly minimum wage was $14.15, and that was under section 664, subsection 1. While we saw 29 cases alleged, there were 1,019 violations found. In a lot of situations, what we find this to be is that the rate of pay, people who are earning minimum wage come January 1, there was not an increase in the rate of pay in order to meet the new minimum wage. Some of that could also have been issues with the tipped minimum wage that Liz pointed out earlier, where the individual didn't receive enough tips and therefore were being paid sub minimum wage, which would have been a violation. We saw 14 citations issued and fines of $36,994. So not an insignificant amount of money for a change that, every January 1, you should be making sure that you're updating wage rates if you are an employer who often employs individuals at a minimum wage rate. Under section 664, subsection 3, that's the overtime provision. So in 2024, you would have had to have paid time and a half for all hours worked over 40 in a work week. Now that's not just bringing an employee up to being paid at $21 and change based off of the minimum wage. It would be whatever the rate of pay you're paying that individual is times 1.5 based off of that regular rate of pay is what's required under subsection 3. And in determining what that hourly rate is, you're going to use that regular rate classification, which includes all earnings, bonuses, commissions, and other and other forms of compensation. We saw fines of 42,647 based off of 20 citations and 1,138 violations. There's a couple of places where we most often see issues as it relates to overtime, and that's for employers who use a pay period that results in 2 weeks. So we've seen a lot of situations in which the payroll is processed and you review the number of hours in that billing in the payroll cycle. So let's say the payroll cycle says the employee worked 80 hours. In a lot of situations, you'd presume, okay, you're just going to pay whatever the wage rate is times the 80 flat payment kind of every um, semi-weekly, semi-monthly pay period or biweekly pay period. But the problem is that it could be in week 1, the individual worked 43 hours, and in week 2, the individual worked 37 hours, and therefore no overtime was paid in that first work week, even though it should have been. So this is in a lot of situations we've seen just an issue in how payroll was set up. So just double check to make sure if you are using any payroll system that pays for multiple work weeks, kind of in the same payroll cycle, that you're set up to appropriately look at each work week individually to determine rate of pay. Also, a reminder to everyone under 664 subsection 4, compensatory time agreements, those are not permitted. So those would be situations where they say, oh, you worked 50 hours last week. This week, you've got 10 extra hours that you can take whenever you want, but we're not going to pay you for those 10 extra hours. Compensatory time agreements are permissible in the public sector in certain industries, but for private companies, which is what we're focusing in on today, those are not permissible. There's not, however, a fine or a penalty associated with it. So we saw one case in which this was alleged N1 violation that did not result in any fines, but just something we wanted to throw in there. If you are doing a compensatory time agreement where someone is able, if they work overtime in one week, they're not paid for it, but they can use the time at a later period, those are not permissible. Let's jump to personnel file and reason for termination, Liz.
Perfect. Okay. So again, these are areas that we wanted to talk about because these are requests that many of you, if you haven't gotten already, are probably familiar with or potentially will get at some point in the future. So Section 630 is related to employees' ability to request a written reason for their termination. And this does carry the potential of penalties from the Department of Labor. But essentially, what the law provides is that in Maine, an employee has the right to request a written reason or statement from their employer about the reason for their termination. And if an employee makes that request in writing, the employer has to respond within 15 days of receiving that request. I mean, we've seen this come in, sometimes from employees, but oftentimes this comes in through an attorney, and sometimes it comes in conjunction with a personnel file request. But the bottom line really is if you get one of these requests, know that there is a statute that requires you to respond, and there is a deadline for responding. If an employer fails to respond to this, there is a fine available of $50 to $500. But there's also the ability for the employee to file a lawsuit. They can go to district court or superior court to essentially enforce this provision. And if they win, they will basically get two things. One, an order requiring you to do the written termination reason anyway. But also the employer might have to cover the attorney's fees. And it is time consuming for an employee or their counsel to go through sort of the court process to enforce this, but the employer will ultimately have to pay those attorney's fees for that time going on. So all the more reason to make sure that you are abiding by the timeline. Personnel files, sort of a similar idea here. Employers have to provide employees copies of their personnel file or access to review them upon a written request. The timeline here is a little bit shorter, so it's within 10 days of the receipt of the request. And if an employer fails to do so, fails to provide it within 10 days of that request, similar remedies in terms of the penalties available, as well as the procedure to go through court to enforce the provision, as well as the employer being on the hook for the attorney fees going through that process. One thing to keep in mind here is that the personnel file is broad. So that's going to include, all formal evaluations, informal evaluations regarding employee performance, any sort of quote unquote reports on the employee's character, credit, work habits, compensation, and benefits. It's a huge definition. So it's important not only to make sure you're providing these documents, really anything that is related to an employee's performance, good or negative, that contributes to any basis for a termination or disciplinary action. But maintaining that as you go and making sure that all of that is provided when you do get a request. The only, you should be aware also that medical records, if they would be admissible in court, so otherwise non-privileged, those would be included as well. In terms of the format for a personnel file, one of the questions we get is, can this be electronic or does it have to be hard copy? It's okay to maintain it in either or format, but as long as it's properly backed up and stored so that we don't risk losing the file and the consequences from that. With that, I will turn it over to Tawny for the next slide.
Let's discuss some unfair agreements. Under Section 629, an employer cannot require an employee to work without compensation or to return some portion of that compensation. And in your mind, you're thinking, gosh, Tawny, who would ever do that? Well, the thing is this is a much broader concept than just like, hey, I'm requiring you to return compensation. It's not saying give me two-thirds of your paycheck, but it's things that are such as, hey, there was a dishonored check, or an individual walked out without paying, or you broke three dishes, or you damaged X, Y, and Z amount of merchandise. Um, Damage, inventory shortages, issues concerning customers not paying bills, none of those amounts can be withdrawn from an employee's paycheck. Those are losses that the employer has to take. Um, we saw 27 cases alleged for violation of Section 629 regarding unfair agreements. 10 citations were issued in which there were 378 violations. Most likely, those 378 violations come from each deduction that's taken from an employee's paycheck that was improper, and it resulted in fines of $117,412. So inventory shortages, cash shortages, dishonored checks, none of those are amounts that can be taken out of an employee's wage. The place in which we most often, as a firm, kind of in giving advice and counsel on this matter, that we see this are situations in which an employer will front PTO or vacation time, and then if that amount hasn't been um, earned by the time a termination occurs, that they attempt to deduct that amount from the final paycheck. That cannot occur unless you have a written agreement in place with that employee that that is a debt that is going to be owed and can be appropriately deducted from the last paycheck. Remember that deductions that you take from an employee's pay, they have to sign it, they have to agree to it. When you're just deducting the amount from the last paycheck, that's not something that they've agreed to and is likely going to result in a violation of 629. So just keep that at top of mind anytime you're considering a new deduction. Let's turn to earned paid leave, Liz.
Sure. So for earned paid leave, here on this slide, we've included sort of a snapshot literally from the wage and hour report. And this shows sort of the progression of both enforcement as well as violations and wages paid for violations of earned paid leave over the course of the past 3 years. So as you can see, 2023 was the busiest year of all. And there's a fairly low number of violations, but the dollars add up quickly when violations do occur. And I think there's really two key elements of this that I wanted to flag today. I'm sure many of you, if not all of you, are familiar with earned paid leave. This is a law put in place back in 2020 or 2021. It's been a while. I can't remember the specific year.
21.
21. Okay, that's right. And it requires employers with more than 10 employees to provide earned paid leave to virtually all employees they employ if they hit, if they're at that threshold size-wise. General rule is that 1 hour of earned paid leave needs to be accrued for every 40 hours worked. And there are certain requirements and restrictions on using the leave in terms of employers need to allow it to be used for any reason, can have only sort of limited notice for planned leave, and there's limited circumstances to deny the use of leave if it is requested. So if you are listening to this and you are of the size of an employer, you have 11 or more employees, you should, and you don't have an earned paid leave policy in place, always a great idea to get one in place because there are potential not only violations, but unpaid wages related to not having that policy and not paying for that leave time if you don't have a policy that would be compliant with Maine's requirements already. Another nuance of this that is important to consider from a wage and hour perspective is how the leave needs to be paid. It's not necessarily paid at the employee's typical hourly rate of pay. Earned paid leave needs to be paid at the base rate. And essentially, that definition is the same as a regular rate for overtime purposes. So the other element of this is it's paid at this base rate. The base rate is based on the week immediately prior to the employee taking leave. One situation where this might come up is if an employee has sort of multiple positions and they work at different hourly rates throughout the week, so their compensation might change from week to week. They might earn more one week than the week before. An employer needs to look at the week immediately before they take earned paid leave and calculate their base rate, or their regular rate of pay, like you would do for purposes of overtime, to calculate what the earned paid leave should be paid at. Um, and potentially underpaying, if that base rate is higher than, say, their typically hourly rate or what's being paid for earned paid leave, that can lead to liability for EPL from the DOL's perspective. So important to keep that in mind if you have employees that might have different compensation, work different hours per week, that those calculations do need to be taken into account in how you pay it. And next slide, please. So we will wrap up with just a few quick words on sexual harassment. This is a situation or a statute under which a number of violations were found, a number of violations were alleged, but not necessarily penalties put in place. But it's something that applies to nearly every employer in the state, or most employers. So employers have a requirement under Section 807 to post a workplace poster regarding sexual harassment. And this, the Maine Department of Labor has their mandatory poster regarding sexual harassment that needs to be included in your set that are in the break room and your intranet available to employees to review. Employers also should have a sexual harassment policy, and that needs to address a few key elements pursuant to the Maine statute. It needs to say that sexual harassment is illegal, should have examples of what sexual harassment could be, as well as include information about the complaint process through the Maine Human Rights Commission and how employees can contact the commission with any complaints. So those are going to be requirements applicable to all employers in the state. And employees need to be notified annually of these elements of the sexual harassment law and policy. Now, there are training requirements for employers with 15 or more employees. For this group of employees need to be trained within 1 year of starting about sexual harassment, again, how it's illegal. Training should address state and federal laws regarding sexual harassment, and the training should also include information about both an internal complaint process as well as what recourse can be obtained through the Maine Human Rights Commission. And it also needs to address the protection against retaliation for making a report of sexual harassment. In addition to educating all new employees, there needs to be additional training for managers and supervisors that's specific to that role and their responsibilities in relation to sexual harassment complaints, how to handle those, and utilize the company's internal procedures appropriately. Record keeping is also an element of this where there are potential violations. So employers need to keep records of the training for at least 3 years. So that's just sort of a brief overview of what your requirements are going to be there, because violations, again, it's around $1,000 fine for the first violation, and that goes up to $5,000 for a third or ongoing violation. So those can quickly add up.
The time in which we see this a lot of times, and you're gonna maybe laugh. I can't hear you, so if it's not funny, then don't laugh. But I won't know, so that's fine. Um, I swear every year we see someone who gets hit with this, and their response is, we painted that wall and we just never put stuff up, or we had construction, we never put stuff up. The fact that multiple people have given me the "we painted a wall" kind of story leads me to believe this is something that's happening regularly, where a wall gets painted and the posters just don't get replaced. Really be mindful with your operations team if you are experiencing construction or something along those lines, that yeah, these pages and pieces of paper might not be the most aesthetically pleasing display, but it is mandated by law. And it's just tough thing to get hit with when all you had to do was get some tape and post these documents. So just a reminder to everyone who may be painting walls in the next couple of months, like make sure those posters stay hung. And with that, I think we have hit the end of our presentation. So thank you all so very much for your patience with us and for sitting through this. If it didn't come out as I was having my coughing fit at the beginning, the presentation has been approved for one SHRM credit and one CLE credit, and you will receive an email from us concerning how to get that certificate. And if you're an attorney, we will be submitting your name to the Maine bar for CLE credit. So it's credited under the Maine bar. Thank you all for your attention and have a great day.